Hi everybody, this is Arkady Frekhtman, a New York City personal injury trial attorney, and today we're talking about economic damages and specifically a recent case in New York. So what happened here was it was a labor law case. A 40-year-old commercial roofing mechanic was injured when he fell from a ladder about 9 feet in the air, and he landed really badly, fracturing his ankle. It's known as a pylon fracture. We actually had a case with a pylon fracture recently that we ended up settling. Very serious fracture. So what happened was he was working for security, for a company called Security, and it happened out in Long Island. And so the trial happened in Nassau County. So the plaintiff won on the issue of fault or liability. He actually obtained summary judgment because in New York, we have labor law section 240 sub 1. So if it's gravity related and you fall like he did from a ladder, you are protected. And so he won on that. And the case went to trial on damages. And the damages result was fairly strong. The plaintiff ended up winning a total of $2 million, $1 million for the past 7 years from the date of incident up until the trial, which happened, I believe, in March of 2022, and then $1 million for the future, 10 more years into the future. And so the jury allowed for economic damages as well. They allowed for medical and physical therapy expenses for the future 14 years in the amount of $1.5 million, lost wages in the amount of nearly $900,000 for the future 10 years, and Social Security retirement benefits of $277,000 for the future 14 years. And then there was also a $125,000 loss of services or consortium claim for his wife. So the total recovery was $5,130,137. But, and this is where it comes in interesting, what happened was the defendants felt that the evidence presented by the plaintiff at trial was not sufficient to support the economic damages award. So what they did was they appealed. Actually, they didn't appeal. They filed a motion under the law to the judge to set aside the verdict. And the judge agreed, saying that the testimony about future medical expenses and physical therapy was speculative at best, and that the plaintiff already stopped seeing his doctor or going to physical therapy. So that's why we always, as lawyers, we always tell clients, don't stop going to your doctor. You see, this guy got like so much money. He got like almost $3 million, and 1.5 million of it was for future medical and physical therapy. But then the judge takes that away because he's saying, look, the patient, the plaintiff, is not going to any doctors. He's not going to any physical therapy. So how can the jury allow for $1.5 million for future physical therapy when he hasn't been going in the past? And he just takes it away, So it's so important for plaintiffs to continue going, especially with a serious injury like this. Just even if you go like once every 3 months, that's only 4 times a year. Once every 4 months, that's only 3 times a year. But go once every 6 months, that's only twice a year. But don't stop going. So anyway, the judge takes it away. What he did was, or she, I'm not sure if this was a male or female judge, but anyway, but the judge changes the 1.5 million jury allowance for future medical expenses and physical therapy, cuts that down to $137,000. The judge takes the $892,000 lost wages jury compensation and cuts that down to $133,000. The judge takes the $277,000 jury compensation allowance for Social Security retirement benefits and cuts that down to $41,000. So basically, the judge cut all of the economic damages. But the non-economic damages, he said, or the judge said they could keep it. The $2 million they kept, because the judge said, look, this was a serious injury. This was a right ankle pylon fracture. It required an external fixator for 3 weeks, followed by surgery known as open reduction internal fixation, hardware insertion, and 2 years later, the patient needed surgery to remove the hardware. He was unable to bear any weight on his ankle for 9 months, unable to return to work for 2 years, and continuing pain. So the ankle fusion surgery was recommended. And it just turned out that, I guess the guy got lucky because he was out of work for 2 years. But then when he did return to work, he ended up making more money in the new job than he did in the old job. So because of that, the lost wages was taken away. But still, $2 million was kept, and some of the money was still kept, about a few $100,000 for the economics. So still a good recovery, but it's a lesson that you have to be able to, really prove your case. So as a patient, the lawyer should really guide you and be that guide, be that counselor, give you that advice that, look, you better go to medical, for medical treatment, because if you stop going, then you're not going to be able to get future medical allowances, which is what happened here. And the other thing is the lawyer, this was actually a very good lawyer who tried the case. I'm familiar with their firm, but the lawyer maybe should have thought of it before the trial and thought, strategized a bit and thought, well, wait a minute, if my client's not going to medical treatment, how am I going to prove lost, future medical benefits? And if my client's really working and making more money than he did before, how am I going to get lost wages? And then that all could have been avoided because he called an economist, he spent money on an economist, he spent, time in the trial. He got this amount, which is excellent, but then the amount gets slashed. Now, I don't know if that's the end all and be all, right? Because that's just the trial court decision. This is from a blog article that another lawyer wrote. He has a blog called Damages in New York. But what the plaintiff's lawyer could do, perhaps, is file an appeal, right? And maybe he can get that reversed and keep some of the economic damages, or at least keep more of them. So I don't know what the plaintiff's lawyer is thinking about that. So it's not the end. It might be a continuing story, but it has some lessons in here. So I thought this was really interesting. Okay, thank you everyone for watching. We are here for you. Let us know what questions you have. And